The thing that really struck me after all the experiences I had with DoNotPay is that the company is advertising a service that it simply does not offer. They are offering a robot attorney that promises to deliver you customized legal products tailored to your circumstances and location with the most relevant legislation, et cetera, et cetera. And that's just not what they do. And advertising a product that you can't actually produce is a deceptive trade practice.
Today on LawNext, Kathryn Tewson. She is the paralegal whose investigation of DoNotPay, the company that bills itself as the world's first robot lawyer, led her to conclude that the company's supposed AI-driven products were little more than smoke and mirrors, and that the company was engaged in consumer fraud. Soon after she published her findings through a series of tweets, DoNotPay's founder, Joshua Browder, announced that he was taking down the products she tested. Now, Tewson has filed a legal action against DoNotPay and Browder in New York State that is the first step in a potential consumer class action. Last week on this podcast, Browder was my guest to respond to Tewson's findings. This week, we hear from Tewson herself. This is Bob Ambrogi, and you're listening to LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. Before we get to Kathryn Tewson, please take a moment to learn about the sponsors whose support makes this podcast possible. Transform the way you run your law firm with Practice Panther. Practice Panther offers cutting-edge features, including automation of billing, storage of e-signatures, and customization of workflows that will free up your time to focus on serving your clients. See why tens of thousands of law firms have made Practice Panther their go-to choice for law practice management software. Visit PracticePanther.com now and experience the difference for yourself. Now on to my conversation with Kathryn Tewson. Kathryn Tewson, welcome to LawNext.
Thanks so much for having me.
I'm really excited to talk to you. You have been so much in the limelight, in a sense, over the last few weeks. I don't know whether it was your intention to put yourself in the limelight so much as you put DoNotPay in the limelight. But before we talk about all that, before we talk about DoNotPay, question I have had so many people ask me is, who is Kathryn Tewson and what does she do? So who is Kathryn Tewson and what do you do?
Yeah, so I am an investigator and paralegal. I work for a New York-based law firm, but I live in Seattle, Washington. And I work on a commercial litigation team. I enjoy my work very, very much. I'm also a professional classical musician and an artist. I sing with the Seattle Symphony, and I have 2 kids.
Well, we're going to be talking later in the program about a petition you filed in New York. But in that petition, it alludes to the fact that you came into legal services later in life. And it says, and you got there because of a fundamental curiosity and creativity in how you approached the space. So what were you doing before you got into being a paralegal?
So my first career, actually somewhat relevant to this, is that I was in technology. I worked at Microsoft in the mid to late 90s and worked at a startup for some time after that. And then that startup kind of did what startups do. And after that, I had my children shortly thereafter. And so I was a stay-at-home mom and a musician for a really long time.
Yeah.
But then in 2019, I should back up. I've always been fairly active on social media, and I've always been fairly outspoken on social, even before they were calling it social media, back when it was just Usenet or blog comments or what have you. And so in mid-2019, I stumbled into a discussion on Twitter, a very high-energy discussion on the merits of a very stupid defamation lawsuit, in which an actor sued 2 colleagues of his and the company that they all did work for defamation for discussing how he had sexually harassed them. And then admitted at deposition that all of their stories were true, but he just didn't like how they phrased it. And this actor had a very large number of very high energy fans who immediately sort of sprung into action when this suit was filed to try and bully the defendants into settling or shutting up or anything like that. And that doesn't sit well with me. And at the time, I knew absolutely nothing about the law, but I But I did know that the plaintiff has the burden of proof and that opinions can't be defamatory. And I do love arguing on the internet and have just about since before there was an internet to argue on. So I sort of leaped into that. And then as part of that, made friends with a lot of lawyers who taught me a lot about civil procedure and eventually encouraged me to first go to paralegal school. And then in very early 2021, so just a little more than 2 years ago now, my boss, Akiva Cohen, hired me on what was going to be a 10-hour-a-week internship for credit at school. And within about 6 weeks, it was a 35-hour-a-week job. And we did 2 trials that year. And then he hired me full-time at the beginning of 2022. And I've been working for him ever since. And I love it.
And the firm you work for is Kamerman Unsick, Sonaker and Klein. Am I pronouncing any of that right?
Kamerman, Unsick, Sonaker and Klein. But we go by Cusk for obvious reasons.
All right. Mm-hmm. And so you've been a paralegal since 2021, so a couple of years.
Since 2021, started school. I registered for classes on the last normal day before the pandemic shut Seattle down. I registered for classes on March 2nd, 2020. So I've been an investigator, hobbyist, volunteer basis for longer than that, but that was the beginning of my paralegal career.
So on January 24th, just a few weeks ago, as we're recording this, through a series of tweets, and then I think later on Tech Dirt, you published your highly critical results of an investigation you did into DoNotPay and specifically 3 of its kind of legal self-help apps, concluding that the apps were not AI as they were billed and might even involve humans behind the curtains somewhere in the process. We can talk more all about that. But what set you down this road? I mean, what got you interested in looking into DoNotPay in the first place?
So I'll tell you, I had heard about Browder's idea of, paying somebody $1 million to use his AI to argue in front of the Supreme Court. That sort of brushed up against the edges of my consciousness, but I didn't give it a lot of thought because if I'm going to be perfectly bluntly honest, it struck me as tech bros being tech bros. And if I got worked up over something dumb a tech bro said, I would never do anything else. But then when I heard about his idea of having the robot AI attorney represent somebody in traffic court, that piqued my interest a little more because it seemed to be in the plausible realm of something that somebody might be able to kind of pull off with sufficient deception. And so I was following that, and which is why I saw it when he tweeted that they had just sent out a subpoena, also generated by AI, for the traffic cop. And by the time I saw that, multiple people had already seized on the fact that, why would the defense subpoena the prosecution's only witness? But a subpoena is a document with legal force, right? Subpoena means under penalty. And so I asked him, who signed that subpoena, Josh? And he did not answer. And so I asked it more than once because I am persistent, and he did not answer me at all. And then I noticed after a while that he had deleted the tweet. So I took a screenshot of his original tweet about the case and then the little hole that says this tweet has been deleted. And then my response saying, who signed that subpoena, Josh? And posted that and said, why did you delete your tweet about sending out this subpoena? And he blocked me. And that was the point at which I was like, So, because
that got your curiosity going.
That got my curiosity going because that seemed like a lot of effort taken already to avoid answering a question. So then I, again, as is my wont, got involved in a lively exchange of ideas about the ethics and practicality of a robot attorney. And during that discussion, just with other people on the internet, not with Josh. And during that discussion, it occurred to me that we were all arguing from our own idea of what a robot attorney is, but not knowledge of what a robot attorney is. And it occurred to me, DoNotPay is a publicly available company. Anybody can sign up for it. I don't have to guess at what this is. I can know. And so I went to log in to see what it was about, to see what it did, to see what it could do. And I will admit, the firm I work for, we use a lot of technology and even some AI products in our regular commercial litigation practice. And I'd heard a lot about ChatGPT, and I just wanted to see, how much intelligence there was in the artificial, I guess. Yeah. So that was really what motivated me.
Let me just ask you something there, because Browder was on this show last week, and in some comments there, and in some comments subsequently that we just published on an article on Law 360, he has sort of insinuated that you were essentially dispatched by your firm to disprove somebody who is looking to take away the lawyer monopoly on helping consumers or something like that.
Yeah, I saw that.
Is there any truth to that?
Zero. Let me be as clear about this as I humanly can be. No. What I said on Twitter is that nobody I work for or with has any need or desire to hide behind me or my reputation. That if this had been done on their instruction, then the suit would have been brought in their names, not mine. And now, to be clear, I do frequently perform investigations at the behest of my firm in the context of client work, which I don't discuss on Twitter because it is client work. And then those findings show up when we file a case on behalf of the client. So no, I did, to be fully transparent, before I chose to file the petition, I did touch base with my boss and say, is it going to be a problem if I file this petition? And he said, no, this isn't firm work. You are a consumer. Do what you want to do. But that was the extent of it.
Yeah. Has your firm been supportive of you in all of the rest of it up to filing the petition? I mean,
yes, we're all very good friends, and my firm, they knew what I was like when they hired me, I guess is probably the best way to put it. And no, they are very supportive in general of me being a visible figure on the internet.
Yeah, well, you've certainly proven your doggedness here, and if anything, you're going to get other firms calling you, wanting to hire you away, probably. So you going back to this decision to kind of try it out. So on January 22nd, I think it was, you signed up as a customer of DoNotPay. You plunked down, what was it, $36? I think for 2 months, something like that.
$18 a month, 2 months up front. Yeah.
And then what did you do?
So I will tell you, first of all, when I logged in, I expected, number one, to find a real-time legal advice AI that you could ask questions for and get responses from. There's nothing like that. But I did see, there's all these, I guess what he calls blog posts. They're under the Learn section of the website that all have a little button at the top that says, solve my problem. Or embedded in the thing, there's like, defamation demand letters in minutes. Enter your email to get started. And so I just basically clicked through and tried stuff out to see what it did. And before I did this, I will say I did read the terms of service extremely carefully, because for one thing, when you're doing an investigation, it's kind of important to see, to make sure you're not going outside the bounds of what the service represents itself as, and make sure you're using it as intended, so that, for the purpose of validity of the results. And so everything I did, I used my own name, my own address, my own phone number, because that's what's required in the terms of service, which makes perfect sense, right? Because you can't have people sending out demand letters in fake names or anything like that. That's just not cool. But I did generate hypothetical scenarios with facts designed to, test how much legal analytic capacity was here, and just sort of took it for a test drive,
Yeah, and you chose to test drive 3 of the applications that he offers others, but was there any rhyme or reason to why you picked the 3 that you picked?
I picked the 3 I picked because they were ones that struck me as things that would involve significant use of the robot attorney functionality.
Yeah.
Something like, filing a complaint, like a customer service complaint didn't seem to me to be something like that. But a divorce settlement that's a legal document that affects your legal rights.
Yeah. So what were the 3? I mean, what were the 3 you decided?
Sure. So the 3 I chose in order, I started with a defamation demand letter. As I mentioned, I got into this industry through discussion of a defamation suit. Right. So that's something that I know a lot about. That was the first one. And then the second one was the divorce settlement agreement. And the third one was, I actually clicked on it, I think, through something that purported to allow you to sue for assault in small claims court. Although that did not end up being one of the options that was available to me when I clicked through the actual tool.
Yeah. So we don't have to go step by step through this, but because I will post in the show notes, link to your original series of tweets, link to the Tech Dirt article, which basically kind of summarized it all in a single article. But, kind of summarize for us what it was that you found as you went through and tried these different applications.
Yeah, so the first thing I found in walking through the first one I did, which was the defamation demand letter, and as I walked through that, it was asking me for the facts and I was putting them in and everything. And there were some things that I truthfully kind of expected it to ask follow-up questions about. For example, my hypothetical defendant in the defamation situation was in California, which has some very powerful anti-SLAPP laws that can cause liability if you're getting outside your lane and stuff like that. And also, frankly, some of my hypothetical statements were opinions, and it just didn't follow up on any of that. But when it was done, it said that my letter would be ready in 1 hour. And that struck me a little odd because an hour is not a computer timeline. That is a human type timeline. I've used AI products in the past, and they don't take an hour to do things. They do things in a couple of seconds. But I figured I went ahead and I moved on to the
even
divorce
a simple
settlement
document
letter.
automation platform just takes a second. So.
Right. I mean, in my thread, I said, even Westlaw can do it. Well, I was going to say instantly, but anybody who's used Westlaw knows that that's not true. But it doesn't take hours. It takes seconds. And then I did the divorce settlement agreement and kind of the same thing. But when that was done, it said it was going to take 8 hours. And 8 hours is a long time for a computer to do something. So by then I was really getting suspicious that there was some kind of human involvement. And I know Josh has said numerous times that nobody is typing up these letters for you by hand, which obviously nobody is typing up these letters for you by hand. And I can get into how I know that for a fact later. But my suspicion was that human beings were doing the research involved, or the research and the analysis. So then I stepped into the sue now thing, which promised to generate me a complaint to file in small claims court, as well as a script to read in court. And then at some point in the process morphed into just writing me a demand letter instead. And I wasn't exactly sure what was up with that, but I kept on going. And when I hit next, it instantly popped up a demand letter. Here you go, right away, in the same kind of timeline I would have expected with the others, in PDF and Word document format. And I could choose between the two, and I downloaded them both.
Yeah.
And so I thought I would look into those while I waited for my other two to be finished, because at that point, I swear to you, I thought that 1 hour timeline was going to come up, and then I was going to have another document to review.
Right. So how did you said you can explain how you knew that these were not typed up? How did you know they were not typed up?
Right. So forensic document analysis is something I do as part of my job. And to be very clear, I don't have like a digital forensic certificate or anything like that. It's just part of what I do. And so I know, for example, any contemporary Microsoft Office document, like Word or Excel or PowerPoint, anything where the file extension ends in the letter X, like DocX or XLSX or anything like that, if you rename that file to .zip, it then becomes a compressed file that you can open up and look at all the structural XML files that are compiled together and interpreted by the program to present you the document that you're familiar with. So I could look at like the raw structure of the document this way. And this is something I do frequently. And so I could see when I looked in that document, number one, the custom XML object containing the reference to the Google Documents tool that it uses to perform the XML injection. And in the main body of the document, I could see the individually labeled in the XML, the fields into which the information that I entered from my prompts would be inserted and injected. It's a mail merge, basically. It's very, very clear. It's a very clear fingerprint. It looks nothing like a human typed document at all.
Yeah. So, and again, I'm not going to just go step by step through all of this, and because we just don't have the time for it. But based on what you did, going through these 3 different apps, trying them out, you reached some sort of general conclusions about the apps and about DoNotPay. So what did your investigation turn out?
So the conclusions that I came to is that I only ever got one of my 3 documents. The other 2, even after the times were up, they did not give it to him. It said it was doing more behind the scenes. And the one document I got had just 0 AI. There was no robot there at all. It was just document assembly technology that at this point is easily 15 years old. And the other 2 documents that might have involved some kind of analysis, I never got. I don't have any way to evaluate those. And so the conclusion I got was that this service that Browder charges $18 a month for and advertises as the world's first robot attorney is bog standard document assembly techniques that have been in use for decades and possibly supplanted by human researchers for the more complex documents. And I mean, there may be other explanations. That seemed like the most likely one to me.
Yeah. So you posted that kind of whole long tweet thread on January 24th.
Very long.
Very long tweet thread, but good reading.
Thank you.
And you posted it on January 24th. How did Browder and DoNotPay respond?
So Browder DM'd me within a couple of hours after when I was done with that thread. I can't tell you the exact time frame, but it was that afternoon. And he basically said, hey, thanks for the feedback. I'll be more in touch later. And then came back several hours later and said, okay, so, thanks for the feedback. We appreciate you testing our product and signing up. Your account was locked. You didn't get your documents because your account was locked for inauthentic activity. And basically, we're not hiding anything from you. We're not typing these out by hand. I'm not going in there manually blocking accounts. You use this stuff in a way that isn't really how it's intended to be used. I'm paraphrasing here, obviously. And,
right.
But basically, thank you. We'll take your feedback under advisement. It was the message I got. And I responded and said, hey, when can I see the documents that I generated? And he said, tomorrow after 2 p.m. And I said, cool, thanks. Send me email. I gave him my work email address and said, send me email. I look forward to seeing him. And then the next morning, he, instead of giving me my documents, he announced that the AI in the courtroom stunt was canceled and that he was shutting down all his legal tools effective immediately and pulling out of the entire space and focusing on consumer rights. And that seemed super drastic to me. I'm not going to lie. I know I looked into it a little bit more. He raised tens of millions of dollars of venture capital on the back of this legal AI. And that seemed like a really abrupt about face for that. So then that got me a little bit more suspicious. I was like, wow. And he refused to provide me my documents and did not answer my email or any of my other questions about it, just ghosted me completely.
Yeah. So wasn't part of his response to you, hey, this robot lawyer stuff is just marketing?
I believe if his exact words, if I remember correctly, or if this is a paraphrase, it's a tight one, were the world's first robot lawyer stuff is a controversial marketing term, but I wouldn't get too worked up over it.
Right. And I mean, that's kind of what he kept saying when I interviewed him last week. I mean, he made that, well, he talked about his example. We haven't talked about him yet. You referred to it earlier, but what he admitted was a publicity stunt to try and, pay $1 million to send a lawyer to the Supreme Court, or the incident to send a so-called robot lawyer into traffic court by sending a pro se litigant into traffic court wired to hear instructions from DoNotPay, both of which he admitted were kind of publicity stunts, and both of which he kind of dismissed as, hey, there's nothing wrong with good marketing, which I thought was a funny term. I don't know if anybody would agree that was good marketing.
Well, I will tell you, I am not an attorney. I'm a paralegal. And if I advertised myself as the world's first paralegal attorney, that would not go well for me. If you advertise yourself as providing legal services and being an attorney, that's not good marketing. That's starting to veer close into some things that the regulating aspects of this industry take a strong view on.
Yeah. So with him, I mean, he eventually closed down your account, said he offered to refund the money to you. did he actually refund the money?
Actually, he didn't offer. By the time he contacted me the first time, he had already refunded my money.
He had already done it. Okay.
Before he even spoke to me. And I explicitly said to him, that's not necessary. I voluntarily chose to do this. I'm happy, paying for the access. But he refunded my money. And then later said, after he banned me, he said, we won't be charging you again, which did make me a little bit suspicious that maybe he had been previously planning to charge me again, but I don't know that. Yeah. So anyway, please continue.
Well, and I think one of the responses he gave you was that, something he said on this show, and maybe he didn't say, you can tell me whether he said this to you, was that the reason that you were getting that 8-hour message for the document to be produced wasn't because it was going to take 8 hours, but because somehow DoNotPay immediately flagged you as somebody who was using the application for artificial purposes, and that therefore they put a hold on your account or something while they could figure out what was going on. And that he later told you, we don't let people come in and just use this with made up facts and made up characters. Am I getting any of that right there?
I mean, you're certainly getting it right that that's what he told you. That is not what he told me.
No, okay.
When he spoke to me the first time, he said that it was flagged for inauthentic activity. But again, it was my first document that was already had a hold placed on it. And I don't know what it was about that could have been flagged as inauthentic activity.
Right,
Certainly, the facts I put in it were not obviously absurd. I didn't use the names I used were reasonable names, etc. And he certainly not in the app did it ever say there's a hold placed on your account for inauthentic activity, contact support, or anything like that. There was no link to contact support. And when he spoke to me, he didn't say we don't allow that. He said he said, straighten up and fly right. Nope. Absolutely no representations about that. He just told me that when the engineer that understood the blocking code got in the next morning at noon, he would talk to them about unblocking me and that I would get my documents after that. That's all he said.
So you never did get the documents.
Never did. Still not.
Never got the documents. Got the account closed down. But then after he told you that he was taking down these 3 applications in order to focus on Xfinity or whatever he was saying, Comcast cases and consumer cases, you were able to go in and find that the applications were still running and functioning.
We're still active. Yeah. Well, I guess what I was able to do is that, as I mentioned, all of his blog posts have sort of a little teaser in them. It says enter your email to get started. But if you're currently logged into the site and you click on those buttons, it will take you directly to the tool.
Yeah. And
so I was able to continue to access those. And every time I would generate, the document request, and it would sit there saying, with the little countdown timer, but I was absolutely able to access them, and nothing about them said that it was disabled or anything like that. And certainly on the pages themselves, it doesn't say this tool is no longer available. It just says, solve my problem.
Yeah. And, I know what I want to ask you about. This is the story. There's so many different permutations to the story that it goes around. And if you already said this, I apologize. But at some point he cited to you, or you cited to him, the fact that what you were doing was perfectly appropriate under the terms of service. And then suddenly it seemed the terms of service changed.
Yes. So actually, before I get into that, if I can take a quick step out to a side thing that happened before that in time. So after my first thread, I was contacted by somebody who mentioned this promise that Browder had made back in November, where he'd said, for every retweet or follow that this tweet gets, I'll buy $10 of medical debt and forgive it and post receipts. And this person contacted me and said he made this promise, but he never posted the receipts. And what I noticed immediately was his phrasing, $10 of medical debt. I'm familiar with the way medical debt works in this country, and I'm familiar with the fact that it sells for about a penny on the dollar. And his phrasing seemed a little disingenuous to me. Like, if you didn't know that fact, it was implying that he would go $10 out of pocket for every retweet or follow. But in fact, the promise he was making could have been fulfilled with about a dime per retweet or follow. And it got 550 something retweets, so he could have gotten out of that for under $60, right? And so I did a little thread on it saying, yeah, so I got told about this, and apparently he never posted receipts, so we don't know if it's $10 per or a dime per, but this is certainly very ambiguous wording. And about 20 minutes after I started posting that thread, Browder popped up and said, I did donate. Here's the receipts. And he posted a screenshot of an RIP Medical Debt receipt. Now, RIP Medical Debt is an organization that I also support. And so I have seen other receipts from them. And so when somebody reached out to me and said, did those date fields line up with the date headings? And I looked at them and I'm like, I don't think they do. And I made another donation just to get the receipt for myself, a small donation, and looked at them, and mine certainly lined up, but his didn't. And so I kind of, again, this kind of image and document analysis is something I do, right? So I snapped guidelines across it in an image program and determined that, the date fields were not in alignment with the headings. And because he had left the donation receipt invoice number on the visible screenshot, I just reached out to the charity and said, hey, I'm a supporter of yours. I have a question about the way a donation was represented to me. Can you tell me when this happened, when this donation was made? And they were like, yeah, that was made yesterday. That was made January 29th. I was like, because this is the receipt that I was shown that says December 2nd. And they were like, oh, yeah, don't know what to tell you. And so Browder had deleted all those tweets by then. I just had saved the screenshot. I sent the tweet to somebody in my DMs and I was able to extract it from the cache. But yeah, he absolutely, as far as I can tell, forged the dates on a charity receipt. For what reason, I do not know, because if he had just come back and said, oh, sorry, I was so busy preparing to send my robot attorney to the Supreme Court that I lost track of things. Thank you for reminding me. I've made the donation now. Here's the receipt. I mean, I probably would have dragged him for that a little. I'm not going to lie. But it wouldn't have been this.
Yeah.
And that's a normal human way to respond to that problem.
Yeah.
But no, but he lied about something he did not have to lie about. And I know on your show, he admitted that he made the donation 4 minutes after I started tweeting. While he had me blocked, by the way, 4 minutes later, he made the donation. And he's taken the position of, so I made the donation. What's the big deal about the date? And my thing is, well, if the date wasn't a big deal, Josh, why did you forge it?
Right. And then lie about it. Yeah.
And then lie about it. And so by the time I was dealing with this later stuff, by the time, the terms of service stuff was coming up, I was already kind of seeing him through a very different lens than I had been seeing him at the beginning. And, and so when he disappeared from our conversation after that, and I was like, what are you doing? And I went and checked the terms of service and found that he had updated them after banning me to make it a violation of the terms of service to test the products.
Yeah. That was one where I got flack from some of the listeners for not pushing him on the forgery issue when I talked to him. Actually, I forgot about the forgery issue as I was talking to him, but I remembered there was a date issue, and he did admit that he did not make that donation until after you pointed this out on Twitter and asked for the receipt. And so, effectively he's admitted that he forged it because it was dated well before the time he actually made the donation.
Yes. By then, I just did not have any reason to anticipate that he would be doing everything in good faith. Yeah. And so when I went and checked the update to the terms of service and found that he'd updated it afterwards. And then as far as I can tell, sheer coincidence. I will tell you, I was archiving stuff on the site. It is possible that I archived the terms of service at the time while I was doing my Twitter thread, but I don't remember doing that. I just want to be very transparent. It could have been me, but I don't remember doing it. Yeah. But there was an archive of the site taken just as I was posting my thread that shows the old terms of service. And then 2 hours later, it shows the new terms of service. Yeah. And the new clause he added.
Following her investigation of DoNotPay, Tewson has now filed a petition in a New York court seeking to force Browder and DoNotPay to preserve evidence that could potentially be used in a consumer class action against the company. Her petition says, in part, and I quote, "Before bringing a consumer class action alleging this is all a house of cards, while petitioner believes she is able to plausibly allege the fraud, petitioner would like to be able to allege the details with specificity, and she would like to give respondents a chance to show that at least somewhere in their startup, something was running on artificial intelligence," end quote. We'll talk more about that petition in just a moment, but first, let's take a moment to learn about the sponsors who support this podcast. Practice Panther is the #1 rated practice management platform designed to help you manage, automate, and scale your firm. Trusted by tens of thousands of lawyers, Practice Panther offers top-notch native features to easily track time, share documents for e-signatures, send business text messages, and process online payments, all without ever leaving the platform. Learn more about what Practice Panther has to offer by visiting them at practicepanther.com. Welcome back to LawNext. My guest, Kathryn Tewson, has now taken the first step in potentially filing a consumer class action against DoNotPay and its founder, Joshua Browder. In this second part of our conversation, we will find out more about that legal action. Also, I'll ask her to respond to some of what Browder had to say when he was on this podcast last week. Kathryn, I want to turn to the petition that you filed this week, which spells out a lot of what we've been talking about in great detail. But you've filed this petition in New York State in order to preserve evidence and for pre-action disclosure and for a temporary restraining order. So tell us why you've done this and what it's all about right now?
Sure. So the thing that really struck me after all the experiences I had with DoNotPay is that the company is advertising a service that it simply does not offer. They are offering a robot attorney that promises to deliver you customized legal products tailored to your circumstances and location with the most relevant legislation, et cetera, et cetera. And that's just not what they do. And advertising a product that you can't actually produce is a deceptive trade practice. So I thought I would move on that, frankly. And given that Josh specifically, and DoNotPay, their specific market is for people who can't afford lawyers and that who don't have other access to the legal system. And he even said on your show, I think, that lawyers have been looking for a while for a way to sue him, but the stakes are so low that it's just not worth it. And I was like, well, it's worth it to me. I mean, I don't like fraud, is what it boils down to. And this feels like fraud to me. But the problem with fraud, as you know, is that you have to plead fraud with particularity. Mm-hmm. And so in the common language, as I tell people, fraud is when one person lies to another person about something important in order to get them to make a decision that they wouldn't have made if they had known the truth. And you really have to be able to identify specifically each part of that, the one person, the other person, the lie, what the reason was that they lied, what the decision was that you made, how your decision was a reliable one, etc. And what I have right now is a lot of nothing that adds up to a lot of other nothing, but I just need some more facts in order to be able to plead that fraud with the particularity that I would like to be able to plead it with, rather than having to go in and possibly amend after discovery. And that's a whole bunch of procedural pain in the tush.
So this
frankly.
is, you have not actually filed a lawsuit per se or a class action, but this is a preliminary proceeding in order to, first of all, say, do not destroy evidence. Make sure you preserve this evidence. Second of all, give us this evidence. And you're asking the judge to order that they preserve evidence and that they turn over evidence that would be relevant to your determining whether there was grounds for a further legal action or a lawsuit here. Is that right?
Correct. That's correct.
Yeah. So is it your intention that if, depending on what the evidence shows, you will bring a class action against DoNotPay?
Yeah, certainly if, there are some potential hurdles to cross there, but the intention, yes, is to bring a class action deceptive trade practices or consumer protection lawsuit against DoNotPay, because this sort of situation where somebody defrauds a lot of people out of a small amount of money is kind of exactly why we have class action lawsuits.
Yeah. What are the hurdles you meant before you can?
There's
just in terms of the evidentiary hurdles.
No, he has a class action waiver in his terms of service, and which I have opted out of, and which was not introduced into the terms of service until I think October 26, 2020. But there are some issues to look at there as to who could get a class certification. But that I'm leaving up to my attorney.
Your attorney, who is J. Remy Green, right?
Who is J. Remy Green, and they are a consumer rights and civil rights attorney, barred in New York and New Jersey. They are very, very good.
Yeah,
and it is an honor to be represented by them in this action.
So, what is it that you would hope would come out of this legal action?
So I'm going to speak very broadly here, right? Because there is a pending litigation and I don't want to speak too specifically about strategy. But ultimately, I'm very sympathetic to the access to justice claims that Josh is advertising on the back of. It is absolutely true that real, true legal representation is kind of reserved for people of means and of extraordinary means in this country. There are many, many, many people who need representation and who simply don't have access to it because of how much it costs. But I think that this product actually has the potential to cause unbelievable amounts of harm. And particularly when I started investigating it, he offered the product to walk people through the steps of applying for United States citizenship, for declaring bankruptcy. And I believe that both of those categories of things are now down, that he's taken those down since I began investigating. But there's still up things for, LLC operating agreements and child custody agreements and just all these things where small errors can really drastically affect the lives of ordinary people in irreparable ways. And I would like to minimize the capacity of DoNotPay to harm those people in those ways.
So you think that people can be harmed by using DoNotPay's applications?
Yes. Absolutely, I do.
Yeah. Is it your goal then to basically shut them down or cause them to change their business model, or have you thought that far ahead?
I would not say that I have. My goals are more oriented towards, the protection of people who might use this than specific changes I would be looking for from Do Not Pay. I'd be basically looking at changes for them to accomplish those goals. I will say that one of the things that's come up a lot from Do Not Pay is their ability to get like Planet Fitness memberships canceled, which is notoriously difficult. And I think that's a great use of the service, where you have to send a registered letter to a specific address to cancel something, which is also, by the way, how you have to opt out of the arbitration provision for Do Not Pay. You have to send a registered letter to a physical mailing address. But that stops a lot of people from canceling their Planet Fitness memberships. He will fill out a letter for you, send it by registered mail to that address, and get your membership canceled. That's great. That's a real value add. Keep doing that stuff, Josh. I got no objection there. It's these other things where these actions could seriously affect people's legal rights that it's just rushing in where angels fear to tread.
Yeah. In the petition that you filed, you or your attorney, through your attorney, make a couple of references to the Theranos case and Elizabeth Holmes. How do you see these as comparable?
I think that from the broad strokes in both cases, you have somebody who is young and well-connected and knows how to speak the lingo and who is offering a brand new way to drastically reduce the operational costs of performing important services via access to new technology. And certainly in Elizabeth Holmes's case, it was not new technology. It was old technology that they were utilizing and lying about the results of it and how that was being performed. And, it was just the sweat of the brow and using stuff that had been done for decades under a shiny new design. And like I said, one of the things we've asked for from Josh, both me individually and then in my attempts to investigate before he shut them down, and now through this petition, is specific disclosure about the role of humans in producing these documents, not in typing them out, but in doing the research and the analysis that he claims is done by his artificially intelligent robot attorney. And Josh has been very reluctant to provide or even discuss that topic. And just the source, that much reluctance makes me suspicious. So that's where I see the comparisons, is that it's promising a new thing with new technology, and what it's delivering is an old thing in a mechanical Turk.
Yeah. I actually asked him about that during our interview because it had come up on my podcast, my other podcast the week before, when somebody on my Legal Tech Week panel had made that analogy to Elizabeth Holmes. And I had asked him about that when he was on this show. And I think his response was that that's grossly unfair. That was a multi-million-dollar fraud involving medical devices, and in his case, it's just bad marketing or something. Or I guess he didn't even call it bad marketing.
I mean, I will say he claims to have 300,000 users, and although his billing has changed over time, it used to be $3 a month, and he would charge you for a year up front, and then it was $12 a month, and he would charge you for a quarter up front. Now it's $18 a month, and he'll charge you for 2 months up front. It's been $36 on that initial sign up every time. 300,000 users times $36 is over $10 million.
Yep.
So it is true that Elizabeth Holmes has been convicted of fraud and Joshua Browder has not, but it was already fraudulent before she was convicted.
Yep. And that's a huge dollar amount, however you sort it. A topic that's come up, something I asked him about, something I've raised on my own blog, something I've heard some other people talk about, is this question of what might be the impact of these revelations about Do Not Pay. Now this petition, this legal action against Do Not Pay. Could there be a negative impact on other consumer-facing legal applications? And I wonder if you have any thoughts on that question.
I do, actually, and I don't think there will be a negative effect. I think, if anything, the effect will be positive, and let me explain why. What it boils down to is that fraud, in my experience, is bad for innovation, and it's bad for innovation in a lot of different ways. It's bad for innovation, number one, in that it unnecessarily and inappropriately inflates consumer expectations as to what can be accomplished with a given technology. At the same time as fraud is revealed, either, through the courts or just through people's bad experiences with it, it destroys consumer confidence in the technology and in the industry. And because fraud claims will always be splashier to make and always be cheaper to put out than people who are doing the actual work, right? And so those splashy claims and those, lower operational costs tend to attract the majority of the investment capital. And Josh has certainly attracted quite a lot of investment capital. And so it sort of sucks the funding away from people who are doing real work and sucks the oxygen out of the room. And it's not good for real innovation, and it's not good for the development of a real industry. Like medical care, like pharmacology in this country, Lydia E. Pinkham's medicinal compound, ton of people loved that because it was just laudanum and cocaine suspended in brandy. But the presence of that product was not good for the development of other medicines, right? Because that's where people are going to spend their money if it's available.
Right.
And
we do no one any good if we're putting forward fraudulent products.
Exactly. It's not good for the consumers, but it's also just not good for the industry. So I would hope that by clamping down on fraud and pushing back against it, the actual useful, viable, important legal tech, including legal tech that uses AI, can come to the fore and really make a real difference in everyday people's lives, including those of legal professionals.
Yeah. I wanted to ask you just about a couple of the things that he said about you when he was on the show. And I mean, one of them was that he said kind of several times, this is just one angry person. This isn't reflective of what other users' experience has been on the site. And he kept kind of trying to bring it back to you and portray you as somebody, upset with him, upset that you'd been banned from the site. And I mean, I wonder, I'm curious, actually, given how much you've kind of been in the limelight over the last few weeks and become kind of the symbol of these concerns about DoNotPay. Have you heard from any others who have had issues with the site? Or what is your take on whether there are others out there who have been harmed by this?
I've heard from dozens of other people who have had personal interactions with Browder, people who are other entrepreneurs in the same space as him, people who have been trying to get their accounts with DoNotPay canceled for years, literal years, with no success. People who have been trying to get him to validate his claims, again, for literal years without much success. And many of those people have been either, very public about their skepticism, or they are afraid to have their names be more public for whatever reason, particularly if they operate in the same spaces as he does. Those are small ponds. It's very relational business, and I understand that. But yeah, no, I can tell you I am not alone. Dozens of people have reached out to me.
Do you know of any consumers who have been hurt in any way or say they have been hurt in any way by using any DoNotPay products?
Yes. More specific than that, I would prefer not to get into at this time.
That's up to you. Okay.
Actually, there is one that I'll speak to, though, because
okay.
it was public. There was a woman on Twitter named Sasha Paralegal who contacted me, sent me her tweet to say, or I guess quote tweeted one of my tweets, which is how I saw it, in which she pointed out that she had been trying to get her DoNotPay account canceled since 2019, that she did not even remember signing up for the site, that she had reached out to customer support on many occasions, and yet she was continuing to get billed $3 a month. And I am a cheeky and irreverent person online. If you've seen my tweets, you know this. I am foul of mouth and sharp of snark. And I quote tweeted her tweet about it with her permission and said, "Joshua Elizabeth Browder, you cancel Sasha's account right now." And 6 or 15 minutes later or something like that, certainly less than half an hour later, the official DoNotPay account reached out to Sasha and was able to cancel her account in minutes that she had been trying to cancel for years. So it should not take a middle-aged paralegal mom voicing the CEO of the company on Twitter to get an account canceled.
Yep.
That should not be necessary. That cannot be the bar.
Yeah. And that was one also we discussed last week briefly. Again, I don't think I asked the question very artfully of him, but he did say that he attributed that to email changes or unable to use her password or get into her account or something like that. As I recall.
Maybe they were sure able to find it real fast after I quote tweeted her.
I'm sure. Yeah. something else he said, he just kind of kept making this point that he felt that he had a right to ban you because you were not using truthful information. And the way he put it, this is, I think, a quote, more or less a quote, is he said, "People can debate whether businesses have an obligation to not ban people, but I stand by people having to submit truthful cases to DoNotPay." And that's really it. So what do you say to that?
Well, first, absolutely, he has the right to ban me. Sure, he doesn't have to have me as a customer if he doesn't want to. And since he's banned me, he both banned my account and also put an IP ban on my account. But I have made no attempt to make a second account, nor would I, because he has the right to ban me. That's fine. What I would say about the truthful information, that strikes me as a little odd that he wants people to use his service for the first time only in a live dispute. That's like buying a car without a test drive to me, or renting an apartment without a walkthrough. Why would you do that? Why would you do that? Why would you put your own rights on the line with an untested product without seeing what it was capable of? But then I found out in speaking to other people that sometimes his products send letters to their recipients without showing them to the customer first. And say sends letters over people's signatures without showing those letters to people for review first. And that was really concerning to me then, because I know in the product the one document I got, there were terms in it and offers in it that I hadn't authorized, that it hadn't asked me about. And so people are sending these things out to whomever with just absolutely no idea what's being sent out over their signatures. And that I find very, very concerning. So yeah, the idea that you should just trust him to do the right thing and he'll just never only use it for real information, he can make that requirement if he wants. It does not seem very consumer friendly or pro-consumer or the way a wise person would interact with a service to me at all.
Yeah. All right, one more of what he said. He basically said Twitter is not the real world. Where this lady from Seattle, I think meaning you, is. He said the consumers don't care about any of that. They just want their Comcast refund, and if they get their refund, they're happy. Goes on to say all these angry lawyers or theoretical claims or Twitter disputes, they don't mean anything to average people. And spreading this robot lawyer message with the Supreme Court really helps people imagine what AI could do for them. So I guess the point he's saying there, if I can put words in his mouth, is his sense is that for the bulk of the consumers who are using DoNotPay, none of this stuff that matters to them that we've been talking about here. What do you think about that?
Well, I mean, I think another way of interpreting what he's saying is that for people who don't have the education, skill, training, or expertise to evaluate whether or not it is a good idea to let a robot handle your legal rights for you, love the idea of a robot handling your legal rights for you, the people who he is targeting who don't have access to standard legal representation, don't have the capacity to evaluate the worth or likelihood of those claims. And so they love the promise they're being sold. And I think that's probably accurate. I think people really do like to hear that they can access services just as good as that of a real attorney for $18 a month. And actually, can I take a quick diversion here? Because I do want to mention something, sure. because the access to justice is a really big thing. So I have an acquaintance, a colleague, who runs a practice out here in Seattle with the charming name of Small Law, SMOLLAW, in contrast to Big Law, right? And her name is Melissa Hall, and this is not a plug. I haven't cleared this with her or anything. I just want to disclose that. Yeah. But she does what she calls like the family practice of law, and she has clients who pay her a very reasonable monthly retainer, in return for which she handles their small issues, contract review, writing demand letters, challenging leases, handling discrimination complaints at work, that kind of thing. And when bigger issues come up, she refers the client to, she does the issue spotting and everything, and then refers the client to somebody in her network who can handle those issues, who will take it on by the hour. And her monthly retainer fee for an individual is $25 a month. Wow. It is a very, very reasonable fee. And that's only $7 a month more than Josh charges. Yeah. And Melissa's a real attorney. So I think the value proposition there is pretty clear. But yeah, I absolutely believe that, I don't know, it seems to me like what he's saying is, once I have successfully deceived somebody, they believe my claims. It's like, yeah, well, that's how deception works, Josh.
Right. Yeah. So where do you see yourself going from here? I mean, has this motivated you to look at some of other products out there to make this kind of are you going to keep an eye on other consumer-facing legal apps and make sure that they're living up to their promises?
I think what I would say is that I will continue to keep my eye on consumer-facing legal apps. This is the first time anything I've done has gotten this much visibility. But as I've said a couple of times, I don't like fraud in general. It's just a personality thing. I don't care for it. And when this isn't the first time I've dug into somebody who I thought was telling lies and causing harm and discussed it on Twitter, and I doubt I'll stop that anytime soon. It's one of the points one of the attorneys I work for said, I think I'm going to mess this up. I'm so sorry. But he said something like, you don't aim Kathryn, you just unleash her. She's more like a cat than a dog. I come up in the morning and she's left, whatever she's brought home and, outside the door. But yeah, and he and I have been friends for a long time. And so, that was clearly meant with love. But yeah, this is not new for me. The attention is new, but the behavior isn't. And I don't see that stopping anytime soon. That's not how I roll.
Were you surprised by the degree of attention this has garnered?
Yes, actually, I was. It was not what I expected. I already had something of a following on Twitter before. I think I had 7,000 Twitter followers before this started. So, not an insignificant number, but now I have 12,500, and that's a pretty big jump. So, and this is certainly the first time I've had this many media requests for anything in my life. And so, I was surprised. I didn't think that this would get an audience outside of the number of people who normally see what I talk about.
Yeah. Well, as I said to somebody else, I'm waiting for the movie to come out about Kathryn Tewson. It's like you're the new Aaron Brockovich or something.
I've had people say, "Who do you want to play you in the movie?" And my only answer is, a lot of people have asked me that question, and I don't have an answer for you. Yeah, because I mean, the truth is, I am not actually that cool. I'm not actually that special. I am persistent and meticulous, which I believe is also an adjective Josh used to describe me. But what I did was not that hard, right? All I did was sign up for the site that anybody can sign up for and give it a spin. Like, that's one of the reasons why it surprised me so much when he said he was going to be pulling out of his entire side of the industry. I'm like, wow, that's a bold move to take, because one middle-aged lady wanted to see some documents that she created through your site. But yeah, it's not really about, I would love to say it's about me. I love attention. I'm not going to lie.
I mean, the key is you did it. And I, one of my first reactions when I saw your initial stream of tweets about this was, how did it take so long for anybody to do that? I mean, I kicking myself as a pseudo journalist here for not myself ever having kind of gone in. I've written about Browder for years. I've interviewed him before. I've never once went in and tried any of the applications. And so you deserve a lot of credit just for doing that and just not taking somebody at their word for what they say they're doing.
Thank you.
You deserve credit for that. So I've taken way more of your time than I'd planned to take up. But before we end, I just wanted to ask you whether anything else that you'd like to say that we haven't talked about, any other thoughts about any of this?
I do think Browder's in over his head to a certain extent. Some of the things he said, both in Twitter and in other publications and even on your show, indicate to me that there's a lot of understanding of the legal industry and what's involved in the practice of law that he just doesn't have a solid grasp on. And whether that's because not everybody can know everything, right? Or if it's because he doesn't think it's important, I couldn't say. But just based on his discussion of how his robot lawyer was going to work for him in traffic court, when he said he was going to have the chat GPT technology move to dismiss, I'm like, so whose decision was that? Was that the robot lawyer's decision, or was that your decision? Josh, was that your analysis or the robot's analysis? And so I think he's in way over his head and doesn't have a solid understanding of the potential for harm that his products have. And I would love to believe that that's just, not knowing what he doesn't know rather than deliberate carelessness, but I couldn't tell you.
Yeah. And I think I've talked to him first in, I think it was 2018. It was the first time I met him and talked to him. He started this company when he was 17 years old. What is he at? He's in mid-20s now somewhere. He's not
26, I think, 25 or 26, yeah.
But apart from the concerns about his understanding of the law, or in addition to those, it just seems to not understand the consequences of what's being talked about here in terms of his company. He seems a little bit tone deaf about the whole thing, and he keeps dismissing this as, one person and it's just marketing. And I think, as you made very clear, and as your petition makes clear, these are serious allegations and involving potential, large scale consumer fraud, and he needs to address them for what they are and not just dismiss them, I think.
Yeah, I mean, I would love it. Frankly, if more tech bros would take that more seriously, I think that would be great. But certainly, he seems to have a very documentedly loose relationship with the facts that he does not appear to be particularly concerned about.
Yeah.
And that is problematic for me in a big way.
Yeah.
When you have people's legal rights in your hands.
Yeah.
And when you're advertising your product as being better than a product that relies on typical human knowledge because it involves artificial intelligence, and there's no artificial intelligence, that's really concerning.
Yeah. Yeah, and I said before, where were the journalists? Why haven't they ever gone in and tested this? But where were the investors who invested in this company? Where's the due diligence on this stuff?
Andreessen Horowitz put several $1 million into this. Yeah. What were they buying, and what did they test drive it? What was going on there? I have no idea.
You have to wonder.
You do, and I don't run in those circles, so I don't know how that normally works. But I don't know. It certainly seems like I put more due diligence into buying my used Mazda.
Right. They should be kicking the tires a little bit on this thing.
They should be kicking the tires a little bit, yeah.
Yeah. Well, Kathryn, I really appreciate your coming on the show, and it's been a real privilege to talk to you. And I hope you'll keep us all posted on the progress of the legal action as this goes. I'm sure you will keep us all posted on the progress of the legal action.
Yeah, I think somebody who was not me or anybody involved in my firm, I should say, but somebody actually wrote a Twitter bot to automatically post the filings as they come up. I forget what it's called, but I can see if I can find it and quote tweet it for anybody who wants to find it, because I'm easy to find on Twitter because my Twitter handle is just my full legal name.
Yeah.
And so, I can see if I can try and boost that into visibility.
Yeah, well, if you can find that, I'll drop it in the show notes for the show too. So
sure, sounds great.
All right, well, thank you. Good to talk to you.
Of course. All right, take care.
Sincere thanks to Kathryn Tewson for joining me today and discussing her investigation of DoNotPay. If you would like to share your own thoughts or comments on today's show, please do so by tweeting us at LawNext Podcast or by emailing me directly, ambrogi@gmail.com. LawNext is produced, engineered, and edited by Populous Radio. I am your host, Bob Ambrogi. As always, I hope you'll join us again next time for another episode of LawNext.